Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Westminster and for the Commonwealth. Draw near, give your attendance, ye shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. I am Justice Sabita Singh. To my right is Justice Catherine Han. To my left is Justice Andrew D'Angelo. The first case on the list, let me make sure, it looks like the parties are here. I know we have some parties shuffling courtrooms today. So we will call the case of Commonwealth versus Terrell Rosario-THOMAS, 23P 1433.
Good morning. May it please the court, Edward Crane on behalf of Terrell Rosario-THOMAS. Juror 38 was the only black person seated in the jury box after the initial voir dire. She stated that she grew up in both Springfield and Kingston, Jamaica. She further expressed an understanding of what it is like to live in these locations. The prosecutor subsequently exercised a peremptory challenge against Juror 38. When pressed to provide a race-neutral explanation for this challenge, the prosecutor stated that Juror 38, having grown up in both Springfield and Jamaica, could understand why somebody in the defendant's shoes would do what he was alleged to have done. She further stated that Juror 38 would have empathy for someone in the defendant's situation. These unfounded generalizations cannot serve as an adequate race-neutral justification for a peremptory challenge. Contrary to the prosecutor's explanation, people who grow up in places like Springfield and Jamaica do not have some sort of inherent empathy for or understanding of criminal defendants.
Didn't the juror explain in a little bit more detail than simply, I grew up in these two places, that she was in the middle because she understood, having seen people who were on both sides of the coin, presumably the coin making better or worse decisions? Isn't that also part of what the explanation was?
I don't think the prosecutor didn't really mention the fact that the juror said she was in the middle.
Isn't that what the empathy could be read to mean?
So could one extrapolate empathy from the fact that she said she knew people on both sides of the coin? I don't believe so. I don't believe you can extrapolate empathy from the fact that she said that she was in the middle and she knew people on both sides of the equation. I mean,
If it were read as sympathy instead of empathy, would that change anything?
I don't think so. Sympathy and empathy, obviously there's a slight difference between the two, but I don't think you can read into her comment that she knew people on both sides of the coin, that she would have empathy or sympathy for people on one side of that particular coin. I think, frankly, her comment that she's in the middle and she knows people on both sides can only serve to support sort of the ideal nature of her as a juror. We want people who are in the middle, don't we? We want people who have life experiences that allow them to see both sides of the coin.
But then she went on to indicate that, or she made comments that the prosecutor, anyway, interpreted to mean that she would have difficulty getting past the empathy that the prosecutor saw in those comments. And the prosecutor, I take it, inferred that the difficulty would mean that she would have more difficulty convicting than not.
Yes.
And is that an unfair interpretation that the prosecutor put on those words, do you think?
I think it is. The juror stated that well, first off, the way that the prosecutor states it is that the juror said she would struggle with the decision of conviction, and she didn't say that. She did not say that. She said that she would have she would be emotional because she might have trouble reflecting after the fact. So she might have trouble after the decision was rendered, but she certainly did not say that she would.
What should she have said? If that was her interpretation, what's the magic word that would have made the difference between what you seem to argue pretty strongly is either a falsehood or something close to it that the prosecutor drew from or how the prosecutor represented the comments? What was the appropriate way to phrase that?
I think the appropriate way to phrase it, and I don't think that this necessarily means that it would have been an adequate explanation, but the appropriate way to phrase it would have been her comments suggested that she might struggle with the decision of conviction. And frankly, I think that the prosecutor should have characterized a number of different things that she said in the explanation in that way. That her comments suggested that she might be able to understand how someone in defendant's shoes would do what he was alleged to have done. Her comments suggested that she would have empathy for someone in the defendant's situation. I think it's quite a jump for the prosecutor to say that the juror actually said these things, because the juror didn't say those things. So I think that is an important distinction. Other factors that I think go towards the analysis here would be the way the prosecutor conducted voir dire, where the prosecutor had no concerns in voir dire, did not raise any questions about the juror's empathy or upbringing in Springfield or Jamaica, how that might lead to empathy, or the juror potentially having a struggle with the decision to convict. The prosecutor asked no questions about these things. The prosecutor's only question was about whether the juror had any experience with the law.
But at that point, we're really only looking to for-cause issues, right? So you wouldn't expect those questions.
I think you would still expect some probing of that. If the prosecutor was truly concerned about whether the juror would have empathy for the defendant or someone in the defendant's shoes, even if it might not rise at that point to the level of a for-cause challenge, one would have asked those questions. I think the prosecutor would have asked those questions if she had that idea about potential empathy in her head. I think certainly a question that would have been asked here would have been about the juror's upbringing, and really, because she didn't state any specific fact about her upbringing that would lead her to have empathy. And I think that the prosecutor really, I think it's telling that she didn't ask these questions. I think the logical way to conduct this voir dire, if you were truly concerned about potential empathy, would have been to ask questions about the juror's upbringing, ask the juror straight up if she had empathy for someone in the defendant's situation, and ask the juror straight up, would you struggle with the decision to convict because of the emotional burden this might have on you? Those questions weren't asked. Another factor is certainly the disproportionate impact this would have on black jurors in Hampden County. Because if this basis that one has grown up in Springfield or a high crime area is adequate to justify a peremptory challenge, it could be applied to the great majority of black people in Hampden County. As I state in my brief, 31,000 of the 51,000 black people that live in Hampden County live in Springfield. Now, if the fact that you grew up in Springfield and you get it, you know what it's like to live in Springfield, is an adequate justification for a race-neutral challenge, peremptory challenge could be exercised against every single one of these individuals, and certainly that would lead to a disproportionate impact on black juror service in Hampden County. Another factor, I think, when we've sort of addressed it somewhat already, but the inaccuracies here, and I don't think that they're the greatest falsehoods in the world, but certainly the way that the prosecutor explained this challenge, she said the juror stated that she could understand why someone in the defendant's shoes would do that. That the juror stated, I think this is really the more critical one, the juror stated that she would have empathy for someone in the defendant's situation.
Are you saying that's what the judge found as well? I mean, that was a representation, but what matters is what the judge found, right?
Yeah, yes, I think it's important what the judge found. Honestly, I'm not entirely sure what the judge found. I think the explanation here is lacking. I don't really know what the, I think the judge's explanation, sort of where the flaw is here, is there's no real explanation as to why the juror's concern about being raised in Springfield in Jamaica is inadequate race-neutral justification. And there's no discussion of genuineness either. So
are you saying that the judge was wrong to indicate that that was race-neutral, where someone grew up? And the judge found that that was specific to the juror, right?
Yeah. Yeah. Sorry. Yes.
So was that incorrect? It was not specific to the juror, that should be read as being...
I totally agree, Your Honor. I don't think that is specific to the juror. Growing up in Springfield, growing up in Jamaica, those are not specific things. I don't think those are sufficiently specific to say that that's personal to the juror. Of course, there's plenty of people that grow up in Springfield and Jamaica. If the court would have no further questions, I'd rest on my brief. Thank you.
Thank you.
Good morning. May it please the court, Travis Lynch on behalf of the Commonwealth. On the question of the standard of review, I would say that the findings are sufficient to show that the judge did engage in the analysis required by Batson, Soares, and their progeny. So the Burnett binding rule is satisfied here.
Could I ask Attorney Lynch, how are these findings different than the findings in Benoit?
The distinction between this case and Benoit is that in Benoit, the judge just makes a bald statement. The prosecutor has advanced race-neutral reasons for exercising the challenge. Here, by contrast, the judge more directly engages with what the prosecutor was reciting or was offering as an explanation. So, again, in Benoit, there's no magic words requirement. I think Benoit itself makes that clear. So I think that's the major distinction. And in Benoit also, there were a variety of reasons that the prosecutor advanced and the judge just said, there's a race-neutral reason. The judge more directly engaged here because he said, well, the prosecutor was paraphrasing. He's actually thinking about what the reasons were that she was offering. And also referring to what the juror specifically said during the voir dire. As to the, so therefore I would say that the findings are, they're there. The findings are adequate for this to be an abuse of discretion review as opposed to de novo review.
If we disagree with you, is there enough on de novo for us to see things as the Commonwealth does?
Yes, I would say so, because this juror expresses concerns about her ability emotionally to handle this trial. She does, I mean, when you look back at the transcript, the juror brings up the fact that she grew up in Jamaica and Springfield in response to a question posed by the judge about, did you raise your hand to any of the other questions? It's at, and the juror had heard, let's see, so the judge says, the question is there anything about the charges in this case that make it difficult for you to be fair and impartial? Tell me about that. And then the juror brings up, so I grew up in Springfield and also Kingston, Jamaica, so I get it. So in context, the juror has heard the clerk read the charges to the veneer. So she knows it's a drug and gun case at this point already.
So anytime there's a drug or gun case and somebody says, well, I know what this is all about because I live in Jamaica, I live in Springfield, the prosecutor can strike that person based on that?
Well, if they say that they're going to have that without more, I'm not saying that. What I mean is, where the juror is saying, I might have a difficulty emotionally handling this case, I get it, I've been there. I don't think that I'm asking the court to say anything more than on this record, this juror could be peremptorily struck.
Should the judge have struck this juror because she was not impartial then?
No, because the juror did say she could be fair and impartial, and I can't say on this record it's an abuse of discretion for the judge to have chosen to credit what the juror said. There's a later segment where the juror says, it's not about being fair and impartial, it's just I might have trouble. So we're not...
Well, I mean, does she actually say, I might have trouble anywhere? It's emotional. It's an emotional thing for me.
Right.
And that's fairly interpreted as, it's difficult for me.
Yes. That's what the Commonwealth would argue there.
Why can't this exact language be used as a guise every time a prosecutor wants to strike a minority? This juror said she's going to be emotional, and therefore I want to exercise a peremptory challenge. Jurors are always emotional. I mean, this language strikes, bad term of art, is similar to language that cases have said prosecutors could always use that type of language, or body language or something like that. And the court has said it needs to be specific to the juror's answer. What is specific about this juror's answer saying, I'm going to be emotional. Why is that a reason for a peremptory challenge?
Because, well, it's not going to always be the case, because not every case is going to cause the juror to say, again, we have to remember that the juror is raising this issue in response to the question about, is there anything about the nature of the charges in this specific case that causes you to have a concern that would make it difficult for you to be fair and impartial? So there's not some broader principle here. I think this is a very record-bound question, I would submit. I don't think there's anything broader. And again, the judge had the opportunity in the first instance to assess the credibility of the prosecutor. And again, this is a big part of why it's important, the standard of review, I think you can reach the same outcome either way, but the judge in this case got to see the prosecutor. The judge is an experienced trial judge in the district court. The prosecutor has some experience as well. The credibility call, I think, here is important. So in response to the question, why wouldn't this just in general allow prosecutors to strike every emotional juror? Well, the trial judge acts as a check on that. If the trial judge didn't believe the prosecutor, he wouldn't have let her exercise the challenge.
What do you say to Attorney Crane's point that were the prosecutor genuinely concerned about this issue, it would have been explored more on voir dire than it was, or at all?
Well, I would say I don't think there's a per se requirement that you explore all of those issues during the voir dire. It would be good if there was a more fulsome record here, but I don't think that there's a per se rule about that.
What do we do with some of what I find is misstatements by the prosecutor in the reasoning? And I'm looking at page 140 of the transcript. Also, she said that she would struggle with the decision of conviction, and that is something she'd have to carry with her. The juror never even hinted that the struggle was with conviction. It could have been a struggle with acquittal. What the juror talked about was she would be emotional when it was all over. So what do we do with the prosecutor misstating what the juror said?
I disagree with the premise that that's necessarily a misstatement. I think it's an interpretation of what the juror was saying. So
I could just as easily have changed the words acquittal to conviction in this, and it would have been a fair, under your theory here, a fair interpretation of what the juror said, couldn't I? Because she never mentioned which side she would struggle with. She didn't say conviction, she didn't say acquittal, she said she would struggle. So if I read, she would struggle with the decision of acquittal, and that is something she'd have to carry with her, I feel as though she may be biased and leaning towards conviction instead of acquittal, because she wouldn't want to weigh that on her. Based on what you just said, that would be a fair interpretation of what the juror said also, wouldn't it?
Well, either way, it would be fair to exercise a peremptory against such a person, because either way, the person in the advocate's view is not going to be fair to their side. Whether they're going to be inclined to one outcome or the other, of course, the prosecutor is concerned about making sure there are jurors who aren't going to be biased against conviction. If the defense attorney had, all things being equal, let's say it was the defense attorney trying to exercise the challenge, and it was as you just said, I would say that that peremptory would also be properly exercised.
I guess I'm struggling with, if our decision is to uphold the conviction based on that language, anytime a juror says, it's gonna weigh on me no matter what my decision is at the end of this case.
If it's going to weigh on them, then they're not really fair and impartial then.
You don't think every juror weighs on them whether they acquit or convict?
Well, most of the jurors don't volunteer that type of information during a voir dire. I would respectfully, I mean, at least based on what I've seen. Unless there are any additional questions, I'd ask that you affirm the convictions.
Thank you.
Thank you.
Thank you both. So the next case on the list is Commonwealth versus BRYAN, EWAN, 23P1258.
Good morning, Your Honors. Thank you very much for the courtesy. My name is Mike Maloney. I represent Brian Euan, the petitioner, the appellant, excuse me. There were two separate questions were before us as presented by the Honorable Judge Szarkansky out of Wareham. It's appellant's understanding that the appellee, the Commonwealth, agrees with our position in regards to the first question posed by Judge Szarkansky, that is specifically, does an FID authorize possession of a firearm in the home? It's our position that it's unresounding. Yes, it does, as established under common law. That said, I'll move into the second question.
Not so fast.
Sir.
Would you agree that the current statutory scheme in Massachusetts is that it's not an FID card that's required for a handgun, it's an LTC?
Yes, I would, Your Honor.
So why do you say that under common law it's not required?
The two-tiered system between the FID and the LTC, it's been long-standing under common law that when a firearm, a pistol specifically, is in possession of someone that holds an FID card in their domicile or their business, then they are protected at that point. And I don't believe that is being contested by the Commonwealth, Your Honor.
But that's not the question that's posed to us. It is a question, according to the judge, of whether an FID card now continues to protect somebody who has a firearm in their home, correct?
That is accurate, Your Honor.
So I go back to my question. Are you saying that we should ignore the current statutory scheme and say that if someone had an FID card long ago, when it was what you needed to have a handgun, that is forever good, no matter what the status of that FID card is?
Absolutely not. Not forever good, no, sir. I wouldn't make a blanket statement like that. I'd say there are 7 variables that could intercept that and change the course of whether or not the firearm would be permitted in the house. Number 1, are they a felony? Number 2, were they hospitalized? Number 3, are they under 21? Are they an alien? Do they currently have an arrest warrant, or are they subject to a restraining or harassment protection order? None of those variables were applicable in the matter here. For those reasons, and those reasons alone, sir, it's appellant's position that while being an otherwise upstanding citizen that would be permitted to have a firearm in his home, that he would be protected under common law. But to answer the core of your question, sir, no, I would not make that a blanket statement, and no, we should not throw out what has been a longstanding tradition in case law in Massachusetts. There are, however, complications here in the two-tiered system between the difference of an LTC and an FID card. And, Your Honor, if I may just take that a step further. If hypothetically we were to say that that a pistol could not be possessed, if we were to say that an individual who had an FID card that was expired, that was in possession of a pistol, if we were actually to take that out a step further, someone could actually be prosecuted in their home that just had an expired permit versus someone on the street that had an expired permit would be operating within the parameters of the law. I suggest that that was not the intent of the creators, that was not the intent of the statute.
Would that second person have to have a license to carry in order for that to be true?
Yes, it would be, Your Honor.
Okay, and did your client have a license to carry?
He did not have an LTC. He had an FID card from
I'm sorry to interrupt you. Go ahead. I didn't mean to cut you off.
yes, Your Honor. He had an FID card from 94 to 2000, expired in 2000.
And no application to renew that?
He didn't have an application to renew, and I would actually take that a step further, Your Honor. If he did submit an application that was subsequently denied, then this would be a totally different circumstance in the case at bar. But that is not the case at hand. I suggest that based on the appellee's response, they're suggesting that the fact that a generation elapsed, which albeit is quite a bit of time between the expiration of the FID card and the allegation itself, but be that as it may, there were no applications, there were no denials, there were no felonies, there were no other extraneous variables that would otherwise have precluded Mr. Euan from obtaining that FID card. In fact, it was actually offered, an affidavit was submitted, and allowed by the Wareham law enforcement officer responsible for issuing both FIDs and LTCs, saying outright, this individual, had he applied, he would be in receipt, he would have received it.
But in that affidavit, the reference to licensure when it is not qualified as license to carry is the having of the FID card?
That is accurate, Your Honor.
Okay.
We don't have the transcript from the jury trial. What was the jury told about that affidavit? Was it a defense? Was it, what was the jury given an instruction on regarding that affidavit?
Your Honor, I appreciate that question. I don't want to misrepresent anything to the court.
I mean, I asked that because couldn't the fact finder, the jury, have disagreed with that affidavit and said, we don't find that credible, in which case the defense is out?
The jury is always allowed to determine the credibility, bias, or the reasonableness of all witnesses. Yes, Your Honor. I'm not suggesting that the jury would be required to take the affidavit for what it said, but I am suggesting, however, that none of the, I'm not suggesting, I'm saying outright to the court that none of the 7 enumerated variables that would disqualify Mr. Euan were applicable here, sir. I'd also just like to point out this, as the court is aware, this was a pro se individual. The 2 previous attorneys that had represented him prior to the colloquy falling apart the day of the trial, between those 2 attorneys, there were 3 separate motions, filed, essentially echoing each other, that were filed under a Di Benedetto-style motion to dismiss, essentially arguing that Mr. Euan should have been subjected to a civil penalty, a fine, in lieu of the criminal charge. Were there any other questions, Your Honors?
Thank you.
I appreciate everyone's time. Thank you very much.
Thank you.
Good morning, Your Honors. Arne Hans for the Commonwealth. With respect to the affidavit in question, I didn't realize that the court didn't have a copy of the trial transcripts. I do have a copy of the trial transcripts. I can send those to the court. I do reference them in my facts section. With respect to the affidavit that was referenced by defense counsel, that was never in evidence. I don't have the transcripts with me, but I have the list of exhibits with me if the court would like to see that. That affidavit was, I think, filed in support of one of the motions to dismiss, but it was never in the actual, it was, that person didn't testify and that affidavit wasn't offered as evidence during the actual trial. So it's not really a consideration for this court.
Well, so Normally, when questions are reported, there's evidentiary hearings or things that happen for the judge to be able to make factual findings in reporting the questions. And it does appear as if the judge did make some factual findings in his reporting. Based on what? Was it the trial? Was it the motion? What were those findings? Where did they come from?
I believe it would have been the trial. The reported question came out of the trial. From my memory of the transcripts, there was significant discussion between the ADA and the judge as to whether or not the Commonwealth had met its burden, whether or not the case should have been dismissed pursuant to a motion to dismiss at the end of all evidence.
Did the Commonwealth at the trial stage, as your opposing counsel alluded to, agree that if someone had an FID card that expired, that makes him exempt as long as the other exceptions don't apply from having a LTC?
I don't believe so, but I'm going off memory here. I don't think...
Is that a concession the Commonwealth is making?
Yes and no. So the licensing scheme seems to be slightly incongruent with the criminal penalties. So the licensing scheme with respect to 140, 129B, that says if you have an FID, you can own, purchase, possess a non-large capacity rifle or shotgun. Under 131, little a, so chapter 140, section 131, little a, an LTC allows you to own a firearm and then rifle, shotgun, as well as large capacity versions of all of those. The criminal prosecution is...
Can I stop you there before we get to the prosecution? It's my understanding, under the current statutory scheme, that if somebody wants a pistol permit, pistol equaling a handgun, they don't apply for an FID card, they apply for an LTC.
That is correct.
So the whole statutory scheme regarding an FID card and a handgun is no longer applicable. You would agree with that?
Correct. So there's a gap here. For whatever reason, you are immune from criminal prosecution if you have an FID and a handgun in your home, but if you have an FID, you can't legally purchase that handgun, if that makes sense. But there's just no, I don't have an explanation for it. But going back to 1995, the first case I found on this is the Statham case, which I cited in my brief, which says if you have a handgun in your home and you have an FID, it's not a criminal act. And there's many cases that I cited that hold that same proposition, including the Guardado case, which addressed gun laws in Massachusetts very recently after the Bruin decision came out. And even that case says if you have a valid FID, you can possess a handgun in your place of business or in your home to protect yourself. I think, citing the Bruin case, they felt that there was a need to be able to protect yourself with a firearm inside your home.
With no offense to the SJC, is it possible the language was sloppy?
Correct.
And they meant an LTC as opposed to an FID because the statutes changed at some point?
Yes, there's certainly a gap between the legislator and the common law right now. Now, with respect to the case at bar, that doesn't really matter because the Guardado court says you need to have a valid FID. And that's not the case here. The defendant's license was not, or FID was not valid. So he doesn't fit within that exemption. And that's the argument that the Commonwealth's making here. The common law states if you have a valid FID, you can possess a handgun in your home for self-defense, and you are not subject to criminal prosecution. But it needs to be valid, and if you look at the statute which I cite, in order to be valid, it can't be expired, or you needed to have renewed the application for the FID prior to its expiration, and then it remains valid unless and until the application is denied, which is not the case here.
So if I have a valid FID card because I'm a hunter and I use a shotgun and rifle,
Yes.
and somebody comes into my home who has a valid LTC and gives me their handgun, here you go, it's yours now, I can't be prosecuted.
That is my understanding of the common law going back to Statham from 1995, and that was, again, they came to the same conclusion in Guardado in 2023 last year. I understand, when I prepared this brief, I had the same opinion as Your Honor. It didn't make sense, but there's a gap between the legislature that controls possession of a firearm, purchasing it, and the criminal prosecution. So I think they wanted to afford some leeway between the two, but I don't have a good answer for why that exists.
All right, I guess we now turn to the second part then. If we accept what I guess is an agreement, I know it's not an agreement as to the second part, but let's go to Chapter 140, Section 131M.
I would just like to clarify, I'm not in agreement with the defendant's position with respect to the case at bar. The defendant cannot benefit from this exemption, the common law exemption essentially, because he did not have a valid license. The exemption exists, and I agree that exists, but it doesn't apply to the defendant. I just want to make that clear.
Fair enough, sorry. Now let's go to Chapter 140, Section 131M, which says that notwithstanding the provisions of Section 10 of Chapter 269, any person in possession of a firearm whose license issued under this section is invalid for the sole reason that it has expired, blah, 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 civil fine. Why doesn't that apply in this case?
So again, I'd like to go back, take it a step back, go to the two-tier system. What you have here is the FID card, which allows you to own shotguns, rifles, not handguns, and the LTC, which allows you to own handguns and large capacity shotguns and rifles. The defendant in this case had an FID. The statute that Your Honor referenced applies only to LTCs.
Where does it say that?
Well, I don't want to spend too much time looking through the actual statute, but I would reference 131M. So with respect to expired FIDs, such a statute and exemption does exist, and I cite it in my brief. It's 129B12. So if you have an expired FID, and it's expired for the sole reason that you didn't renew the application, and you're found in possession of a shotgun or rifle, then it's still subject to criminal prosecution, but the max penalty is a civil fine. So that applies to expired FIDs, which is what the defendant had in this case. The other one, 131, is the statute that governs LTCs specifically. 129B governs FIDs, 131 governs LTCs. So if you have an expired LTC, that same exemption applies. You know, if it's expired for the sole reason that you didn't renew it prior to its expiration, and you then are found with a handgun in your home, it's still a criminal charge, but the max penalty is a civil fine. So the defendant here, there's two exemptions at play here. He doesn't benefit from either of them because they're both affirmative defenses, which is the second argument that I make in my brief, which I think is an important distinction, notwithstanding the third argument. So he had an affirmative duty to raise this issue prior to trial. He did not raise any affirmative defenses or give notice of any in compliance with Rule 14b3.
A motion, 3 motions to dismiss isn't affirmatively putting the Commonwealth on notice that that was a defense that was going to be raised? 3 times he filed a motion saying civil penalty applies. Why isn't that affirmatively putting on the Commonwealth on notice that they're going to raise that at trial?
That's fine, but the defendant didn't raise any issues at trial. He rested without submitting any evidence or argument. So there's still, at trial, he'd still have to avail himself of that defense.
He didn't put on, see again, we didn't have the transcript, but he didn't put on any evidence that at one point he had a valid FID card?
There was evidence, he did not. And there was evidence presented that he was issued an FID card in 1991, that it expired in 2000.
So why isn't that enough that the civil penalty portion is in play at trial. It's not a jury question of what the penalty is, it's a judge question for the penalty. So the jury convicts appropriately maybe, and now it gets to sentencing and the defendant says, okay, judge, I'm convicted, but the appropriate sentence is a maximum fine. You're on notice of that, right?
Yes. So Commonwealth v. Harrison is very much on point. It's a 2021 case that I cite in my brief. It says that the defendant can't just rely on the Commonwealth's witnesses who would testify that he once had an FID or whatever. So he didn't actually raise this issue, and he can't rely on what was presented in the Commonwealth's case in chief to gain that defense.
Doesn't that case discuss pre-trial? The defendant never put the Commonwealth on notice that he was going to raise that issue, and the case said just because the Commonwealth presents evidence, that's not the affirmative defense. Isn't that what that case stands for? That the defendant has to let the Commonwealth know before trial that they're going to raise this defense at trial.
Yes, that's fair.
So, I mean, how much more notice do you need? There's 3 motions to dismiss where he talks about this as, if I'm convicted, I shouldn't even be charged with this because it's a civil penalty. What should he have done?
He would have had to present evidence that he had actually not reapplied for it. There was, I think, I'll move on from this.
Is there any requirement in any other affirmative defense that the defendant has to present evidence in self-defense, which is an affirmative defense? The defendant can rest on what the Commonwealth presents as a self-defense argument. He doesn't have to put on any evidence of that.
That's fair. I don't have anything else to add to the argument, Your Honor, respectfully. Now, with respect to the exemptions, they just simply don't apply to this case. So the exemption for FID cases is 129B, subparagraph 12. So if you have an expired FID and you're in possession of a rifle or shotgun and it's solely expired for the fact that you didn't renew it, you're not subject to the criminal penalties. You're subject to civil penalties. That doesn't apply here because the defendant wasn't in possession of a rifle or shotgun, he was in possession of a handgun. The other exemption is 131M, which controls the LTC exemption, which says if you have an expired LTC and then you're found in possession of a handgun, shotgun, or rifle, and your LTC is expired for the sole reason that you never renewed it, again, civil penalties apply rather than criminal penalties. In either way, the conviction is affirmed, but the sentencing is really what is at issue. That doesn't apply here because the defendant never had an LTC. So he can't claim he can't claim the benefit of a license that he never held. And that's an issue that's addressed in the Bachman case, which I cite. It's somewhat of a parallel argument where that defendant didn't have an FID, but his friend had an FID, and then he argued that he should have been subjected to this exemption that allows him to be present because his friend had an FID. That argument was unavailing to the court because it would have mattered if they only had shotguns and rifles, but there were 44 counts of various weapons, which included firearms. Neither of those 2 individuals had an LTC, so they couldn't avail themselves of that exemption, which is very much the case here. Essentially, the defendant wishes to avail himself of the exemption under 131 M, which he cannot benefit from because he never had an LTC. Thank you.
Thank you. Matter is submitted. The next case is Kevin McDonald versus JP Morgan Chase Bank, 23P 687. So the parties in this case, just so everyone is clear, we have 15 minutes for each side. There's no rebuttal. So will the appellant please approach the podium to begin?
Good morning. Kevin McDonald, pro se appellant, McDonald versus J.P. Morgan Chase Bank.
Good morning.
I'm sure the court's aware of the case after having read the brief, that it's pertaining to a foreclosure. Particularly, we're here today because of lower court's ruling that the appellant, me, did not have standing in particular on this particular case, which I believe is a clear error of law. And I think that's really the simple part of the case for this court to be able to recognize that error.
So can you tell me in what way did you have standing?
Okay. Massachusetts General Law, Chapter 190B, Section 3717, provides for an emergency action by a co-representative in an estate. And it's clear in the law that that provision is an exception to the law. And
what was the emergency?
Unable to come to terms with my brother, who was a co-representative, contact him, questions that have arisen as to questionable mental capacity or possible substance abuse deficiencies causing poor judgment. And the other aspect is the position of my having other rights relative to adverse possession, having had over 20 years in parts of the home exclusively, in other parts of the land, which equipment was parked on for 20 years.
Mr. McDonald, could I just ask a question with respect to the reference that you made to some substance use problems or mental issues? Is that something that is does that relate to your brother?
It's questionable why somebody would want the house to go to foreclosure and why there wouldn't be any cooperation or action taken to preserve the estate.
I see. And is that something, has your brother's position changed over the life of this litigation on whether he was in favor of the foreclosure or not in favor of it?
I honestly don't know, because I've been doing all the work and I've been putting all the effort into it, maintaining the property, and so I honestly cannot answer that question. He has not come forward, in fairness to your question, he has not come forward saying he's for it or against it. I guess he probably sees that I'm doing all the work and the research and putting the effort into the court and bringing it to the court's attention of the errors of law, the violations of the defendant, Chase Bank, for their failures in complying to the in compliance with the law, such as proper notification for foreclosure, and then those particular things, I think, are the simple matters of the case. But the defendant, the complex matter of the case, in the defendant's reply to the appeal, something concerning was brought up, and if it pleases the court, I'd just like to bring that to your attention, that J.P. Morgan Chase Bank is a privately held corporation. However, the defendant notes that there is a company called Vanguard Group, an investment advisor that has investment vehicles and other institutional accounts that owns 10% more of J.P. Morgan. And that's the complex part of this, because when a plaintiff's rights are violated, such as the 14th Amendment, which provides for no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws, which I think was violated here clearly in not being able to go to trial, and with the recognition that the court erred in not recognizing the exception in the law of an emergency action, the due process aspect of the my rights have been violated. But getting back to the complex matter, which has broad implications and societal ramifications, would be that if a mortgage company is writing mortgages and their investment vehicle is tied into, say, a community, a municipality, such as Wilmington, which is clearly fraudulently over budgeting and crushing people in taxes to the extent that they have $40 million in free cash. It raises the questions, if due process and this issue is not able to be adjudicated and discovery made and a proper vetting out of the aspects of the violations and the deprivation of somebody's rights under the law, the widespread ramifications are that justice is not being carried out for society, particularly like in my particular town of Wilmington. And so I realize that we're not here to really drill down into that, but we're really here to discuss the failures of the court or the errors of the court, which personally I think that the strongest type of ground for appeal is for this court to look at the errors of the lower court with respect to the violations of the law. Clearly,
Go back to Justice Singh's question, though, I think early on, how is it that you are claiming ownership of this property that gives you standing to raise these arguments? What's the basis for your claim in that regard?
Okay, different aspects of the case as far as the adverse possession aspect or the overall?
Sure, in whatever order you
okay,
would like.
I'll give you a little bit background. I've lived in the house since 1976. If you read the brief, you'll see that the appealee was talking about my mom, Jean McDonald, taking title to the property in 1989. There was a period of time when we lived where it was under a different owner's name, under a trust name. There was a divorce. It went into her name. But the bank failed to perform due diligence to identify if there was a clear title without any aspects of adverse possession, which I'm clearly taking the position that there is. And
Is that, but this is your family home, right? So I assume your family allowed you to live there, right?
there was never any question of permission or anything like that. I guess we could go down the path of ownership, personal ownership, like in terms of family, in terms of, for example, when the orator of the court announces your justice is coming in, he said, God help the Commonwealth. So if we go down the path of possession of a person, does God own me or do my parents own me? And I take the position that my ownership is from the Lord, is from God. And I believe that in terms of God saving the Commonwealth, I believe that our country is founded on the principles of life, liberty, and the pursuit of happiness for all people, and that we're a nation of life and liberty. And for us to have a society where one is oppressed and there's not the sense that there is wealth projected amongst all people or simple rights to property that's not going to be adjudicated properly or people's rights are going to be denied, I think it's a concern for society. There are some aspects of this case that the defense counsel has brought up where the courts have never ruled or acted or had any trials on things of matters of emergency action. I take the position that emergency action, losing your home, losing your residence, is an emergency.
Can I ask you, how much time was there from the time that you understood that the house was going to foreclosure and the time that you filed the suit?
I don't have the exact time right now, but the other thing that I did forget to mention is the even questionable part if the loan was even legitimate, legal, or a predatory loan. Because knowing my mom and her health condition and her income situation, and the fact that she already had a mortgage, and she came up to me on multiple occasions asking me, I don't understand what's an equity loan. I don't understand what an equity loan is. And so that caused me to take pause and to think, what kind of institution would lend some money to somebody who couldn't afford it? What kind of institution would lend some money to somebody who did not understand even what an equity loan was?
But again, to get to that argument, we need to make sure that you've got proper standing to make those arguments on her behalf. So we get back to the standing and the emergency issue.
Correct. So getting back to...
So I'm trying to figure out how much notice did you have that the house was going into foreclosure?
I don't have an exact time on that. However, I will say that I've learned a lot about the law since that has come about, but there are also other concerns that I have regarding the foreclosure process, because what I noticed is there's a law firm that handles most of the foreclosures, and I've discovered something that I question whether or not it's nefarious, where they're advertising an auction, and this happens over and over and over again. They're advertising an auction, and then they cancel it. And then they schedule it for another date, but they don't advertise it. And it's almost as if they're inviting their hand-picked friends of investors to come there. And so that is the case that happened here, where the foreclosure was actually advertised and then canceled, not re-advertised, and then a handful of people showed up. There's also the aspect of unjust enrichment, where I'm entitled to equitable proceeds from the property. And I think the brief clearly states these positions, and it's backed up by law. But I think the questionable thing that you have in your mind, and I think you were probably right in questioning it, is what's an emergency? How much time is an emergency? If I told you that I had 6 months or 6 weeks or 6 days, what constitutes an emergency, and does a person's lack of knowledge of the law, procedures, and that sort of thing play a part in that emergency question? Because you folks are doctors of the law, and you spent your life studying the law. But those of us that do manual labor, and we're not in that profession day in and day out, we lack that knowledge and that information. So it takes us time.
Could I just ask you, your time is coming to a close, but let me ask you in terms of the question about emergency. Is it an emergency if you and your brother simply disagree about what to do?
I think it is. I think it's absolutely an emergency because one person lived in a house, one person didn't. One person has a sense of responsibility and the other person's in question. The other person may have been involved in the proceeds of the loan or the process of it, and so there are a lot of questions that still have to be answered, and to not be able to have due process because of a technicality that's really in question. And I just feel as though the law clearly spells out that there is an emergency, and we might be able to agree to disagree on the amount of time that's an emergency, the amount of education that's emergency, but I think we could all agree that it clearly states in the law that there is an exception for an emergency.
Thank you very much.
Thank you for your time. And thank you for your willingness to even bring this before the board today. Thanks all. And the one thing that I forgot to mention to you, getting back to...
You have a question?
I just...
Because the argument is done, so...
Okay, can I just say one thing?
Actually, if you
Okay, no
have
problem.
a seat, please. Yes.
Good morning, Your Honors. Attorney Michael Juzik for Appellee JP Morgan Chase Bank, N.A. I just wanted to begin briefly by talking very quickly about what this case is not about. This case is not actually about possession of the property in the sense of whether or not Mr. McDonald is going to be evicted or forced from the property the next day after this court issues its mandate, if the court rules in favor of JP Morgan Chase and upholds the Superior Court's order. What this case actually is about is Mr. McDonald's standing to raise the challenges that he's raising to JP Morgan Chase's foreclosure activities. I also wanted to note as well, because Mr. McDonald mentioned it towards the end of his argument, the foreclosure sale in this case, the mortgage has been in default. There's no question about that. That's uncontested. It's not in the record, I don't believe, because of the standing issues. We don't have as full of a record as we otherwise would have about the foreclosure process. However, I did ask my client about this, and the mortgage is due for the payment due March 3rd of 2019. The date that is in the record is that JP Morgan Chase instituted its foreclosure proceedings in November of 2019. So we're coming up on close to 5 years ago that the foreclosure process was begun. And generally what that entails, and again, the record's not fully developed because of the standing issues, we never got that far. Generally, when a foreclosure is initiated, that means that the bank is either sending the notice of acceleration to the borrower, which in this case would be the estate of Mr. McDonald's mother, and or publishing a notice of the sale in the applicable newspaper.
You make an argument that the issue's moot because there's no sale. Stand by that argument?
Yes, Your Honor. So what happened was the foreclosure sale went forward in October of 2021. There was quite a gap between when it was initiated, when the sale occurred, due to COVID and moratoriums on foreclosures. So the sale occurred, or I suppose I should actually say the auction occurred on October 6th of 2021. As Mr. McDonald indicated, several people were there. The high bidder at the sale was a third party, and submitted the high bid. And ordinarily, that party, upon signing a memorandum of sale, the sale would have ultimately closed sometime after the foreclosure auction, and then that party would be given a foreclosure deed from the bank and would then be on title, and the mortgage would be extinguished. However, in this case, because of this litigation, the foreclosure sale was ultimately rescinded. So there is no deed going from the bank to the third-party buyer. So what that means in this case, Your Honors, is that the mortgage has not been extinguished. it's still a valid lien on the property. And essentially, any challenges to, and this would be substance if we leave standing aside, but any substantive challenges to whether or not that October 6th auction was conducted in accordance with any particular Massachusetts law or regulation, or it was a commercially reasonable sale, all of those types of arguments are moot, even if Mr. McDonald had standing to raise them.
Did Mr. McDonald also raise some challenges to the loan itself, independent of the sale process?
Yes, Your Honor. Essentially, he raises challenges to the validity of the origination of the loan. Now, again, I'll leave aside the standing because we briefed that, and Mr. McDonald, it's clear, and there's no dispute. He did not sign the promissory note. He did not sign the mortgage. He has not assumed any of the loan documents, so he's not Chase's borrower in this case. So we would say he lacks standing to raise any sort of challenge to the origination. Also, for the reasons set forth in the brief, and which we can get into as well, as a co-personal representative of his mother's estate, he also lacks standing because he does not have his brother's consent to bring this suit, and the emergency exception does not apply here. However, the mortgage loan was originated in July of 2005, so nearly 19 years ago. And Ms. McDonald passed away in 2013. So even if Mr. McDonald had standing to raise challenges to the mortgage, either individually or as a co-personal representative, any conceivable challenge that he could raise to the validity of the mortgage is certainly time barred at this point. For example, the Federal Truth in Lending Act has a 3-year statute of limitations, and I believe the arguments that he's making appear to implicate the TILA. Theoretically, he could also be intending to assert a claim under Chapter 93A, leaving aside the fact that no demand letter is alleged or was ever sent under 93A. Again, those sort of claims would be barred by the statutory time limits.
Making a mootness argument as to those claims as well?
I think those are slightly different,
Okay.
Your Honor. Those are more of a time bar. There's also a statute of repose. I would argue. It's cited in our brief. However, in some of Mr. McDonald's arguments also appear to challenge kind of the formalities of the execution of the mortgage and/or how it was recorded. Under Massachusetts law, however, any sort of irregularities with the execution of a mortgage need to be brought within 10 years after the mortgage was recorded. Here it was recorded in July of 2005. So any claims as to the formalities with respect to how the mortgage was executed need to have been brought in 2015. So those sort of claims are time barred as well.
So could we now move to the issues that that the case was decided on summary judgment? So there were cross motions?
Yes, that's correct, Your Honor.
Okay. And standing, so there was standing with respect as a personal representative, and that issue the judge found there was no standing because he doesn't have the other party, the brother. All right. And what about the adverse possession issue? Was that what personal standing was based on?
Correct, Your Honor. So the Superior Court looked at it in two ways. I think given that Mr. McDonald is a self-represented litigant, the Superior Court looked at standing in two potential ways. The first was whether or not he could bring the suit as co-personal representative. That's what the court dealt with first. And then the second aspect that the court looked at was whether or not Mr. McDonald had capacity to bring it in as an individual capacity, and whether he had standing to do that, because that was actually how the complaint was signed, was as him as an individual. Again, I think that there's no dispute that Mr. McDonald did not sign the mortgage documents. There's no argument that he's on title. In fact, he's not. The title was in the name of his mother at the time of her death, and now would be the estate. Now, with respect to adverse possession, the Superior Court correctly determined that there's no evidence in the record that Mr. McDonald's possession of that property, or 2 rooms of the property, was adverse to that of his mother. I think there's a couple of important points to note that flow from that. The first is, no case has been cited by Mr. McDonald, I haven't found any either, that says that a person can adversely possess 2 rooms or several rooms within a private single-family residence or any sort of structure. That's not really what adverse possession as a doctrine is about. That adverse possession is about possession of sort of portions of land that are undeveloped, not portions of a house. So it's unclear to me that adverse possession could ever apply, at all when someone is indicating that they think they adversely possess portions of a house. That also indicates too there was no exclusivity of his possession. So Mr. McDonald can't make the claim, or that there's no evidence that Mr. McDonald possessed the entirety of the house. He admits in his own brief, and here before this court, that he occupied 2 rooms of the property. So he doesn't have any sort of exclusive possession of the property as a whole. Another also corollary of that is, since it was admitted as the family's home, there's really no question here that as to whether or not his possession was adverse to that of the owners or his mother. I think just the fact that it's a family home, I think the court can draw the reasonable inference, and the Superior Court certainly did, that he did have his mother's permission to be residing in that house, especially given that he indicated that he started living there in 1976. There's no evidence that his mother or anyone else was excluded from the rooms that he occupied under the adverse possession case law as well. The adverse possessor, we need to show that he or she utilized the property in a way that a common owner reasonably would do so. I think, again, it's not much of an inference or a leap to determine that generally an owner that owns an entire property is not going to confine their activities to 2 rooms of a house. There's nothing in the record about which those 2 rooms were.
So if we put aside the adverse possession claim, is there an individual interest that he received from he's entitled to the residue of the sale, right? He and his brother.
Yes, Your Honor. The terms of the will were undisputed, and as relevant here, both Mr. McDonald and his brother Darrell were given 120-day options to purchase the property. So either one could have purchased that property years ago upon their mother's death. The will further provides that if neither one did exercise that option, then the property was to be marketed and sold, and the proceeds were to go to the residue of the estate, which is then to be distributed between the 2 brothers. So the will does provide exactly for this situation as to when the options to purchase were not exercised, and that is that the property is to be marketed and sold. Here, of course, the mortgage remains as a lien on the property and was unpaid, so therefore, under the mortgage documents, Chase initiated the foreclosure proceedings.
But does that give him some individual basis to bring this claim, that interest in the residue?
I don't believe so, Your Honor, because the will is clear as to what is to happen with the property. He doesn't have any interest to the title of the property. Whether or not he may have some sort of, and I can't even speculate on this, but some sort of continuing right to occupy the property post foreclosure, that would be subject of a separate action if the foreclosure sale ultimately goes through, perhaps in like a summary process action. But as far as for standing to challenge the foreclosure, I don't believe that he has any standing as either an individual or a co-personal representative, given that his brother does not consent to this suit.
So let's get to the question of emergency. I think you've pointed out in your papers that it hasn't really been interpreted. How should we look at an emergency?
Yes, thank you, Your Honor. I think in this case, the statute, it's Chapter 190B, Section 3717. It's relatively clear, and as well, the appeals court has also held in other cases that we cited in our brief that the court essentially looks at the dictionary definition of the word emergency, and Black's Law Dictionary defines it as a sudden and serious event or an unforeseen change in circumstances that calls for immediate action to avert, control, or remedy harm, or an urgent need for relief or help. And the Massachusetts courts as well have applied similar definitions. So I think here, and again, granted that no other court has interpreted the emergency exception in the context of an impending foreclosure, I think here, to the extent that a foreclosure could ever constitute an emergency, and again, I suspect it likely cannot, because this Commonwealth has rigorous rules and regulations as to how a foreclosure is to be noticed and conducted that provide notice to all interested parties prior to the sale.
But maybe the emergency here isn't really the time frame but it's the fact that he and his brother cannot agree on what to do about it, but something needs to be done to preserve this estate and get the fullest value out of it.
Right. Thank you, Your Honor. So again, now we can go right back to the statute as well, because the emergency exception states that the restriction should not apply. In other words, the restriction requiring all co-personal representatives to agree with filing the suit. It says that shall not apply, quote, when the concurrence of all cannot readily be obtained in the time reasonably available for emergency action necessary to preserve the estate. So here we don't have an issue of timing. The real issue, and I think we heard it today as well, is that Mr. McDonald's brother simply does not agree with filing this lawsuit. It's stated in Mr. McDonald's brief that there's a fundamental disagreement between the two brothers as to what should happen with the property. So I think that fact that there's a fundamental disagreement about what should happen takes us right out of the emergency exception, because it's not a situation where Mr. McDonald simply lacks the time to get his brother to consent, like he can't contact him, or there's some sort of medical issue going on where Darrell McDonald is not available. It's clear that discussions have occurred, and Mr. McDonald's brother simply does not want to fight this foreclosure sale. So therefore, we're outside of the realm of an emergency action in a time frame where the consent of the other representative cannot be reasonably obtained. And I believe I'm pretty much at my time, Your Honor. So if there are any other questions, otherwise I'll rest on my brief.
Thank you.
Thank you, Your Honor.
both. The matter is submitted. Okay, so at this point, we'll call the next case. That's John Doe versus Sex Offender Registry Board, 23P 707. Just want to remind the parties that this case contains impounded materials, so please act accordingly in terms of references to parties and individuals in the case.
May it please the Court, my name is Ilse Nearing, and I represent Doe. The classification must be vacated because Doe's substantial rights were prejudiced by the Board's unlawful action. First, the hearing examiner erroneously applied factors 24.2 and 12 to the underlying facts of Doe's case. Second, the underlying facts and the examiner's analysis of the remaining static factors did not clearly dictate a level 3 classification over a level 2 classification. And finally, the outcome was affected by the hearing examiner's erroneous actions, because in her discussion, she cited the 3 factors or the alleged underlying facts 14 times as material evidence to support Doe's classification. So, contrary to Sorb's assertion, factor 24 was preserved because before the agency, in his proposed finding of fact and conclusion of law, Doe raised that the sex offender treatment offered to him was not confidential. And if we look at Doe 23656, even when the factor 24 issue was not briefed, the SJC ruled that where the treatment is conditioned on a waiver of confidentiality, the refusal of treatment alone is insufficient to support an inference that the offender does not want to be treated. And even when the matter wasn't briefed, the SJC excised factor 24 from that offender's classification.
Attorney Nearing, if we assume that the issue is preserved, does the fact that in this case there were multiple reasons given by Doe for his failure to participate in sex offender treatment permit us to infer first that his reason, permit the judge to infer that Doe's reason for not completing sex offender treatment was not the compelled admission portion?
I believe that the reasons,
And I'm thinking specifically.
yes, there were multiple reasons given, among others, his concerns that people were changed. But the common thread running through it was the treatment offered wasn't confidential. He had appeals pending, just as Doe 23656 said he did. And he said that he fully intended to engage in sex offender treatment upon his release from prison while he was on probation, so that all of this together did not support an inference that Doe did not want to be treated. And the hearing examiner did not select one of those reasons. In fact, the bulk of her reasoning was that he was saying the program that he had taken, Man's Greatest Battle, he was saying it was a substitute for. And, well, that simply wasn't correct. Doe even said it wasn't a substitute.
If the examiner had found specifically that it was because Doe felt that the people who took sex offender or engaged in sex offender treatment that he knew became more misogynistic and were less good people as a result, if that's the reason that the examiner had explicitly found, could she have relied on that?
But on the other hand, she never even addressed the fact that he said that he would engage in the treatment if he were protected in his confidential, in his statements, he called them compelled answers, and that he was saying that he had appeals. And a hearing examiner must face troublesome facts. And when in two cases, Doe 23656 and in Commonwealth versus Hunt, the SJC has this rule that where the sex offender treatment offered, the hearing examiner needed to address those troublesome facts and why she said that that wasn't part of why Factor 24 was going to be applied.
I understand your argument in that way. What I'm trying to get at is whether it's your position that once there is a reference made at any point to the fact that there's a compelled admission involved in the sex offender treatment, does that mean that regardless of all other considerations, that factor has to be removed from the examiner's consideration?
That, if I understand the question,
Just
it's the question that if the offender says he's declining non-confidential treatment, does that mean Factor 24 has to be removed?
if that is one of any combination of other factors, if that's mentioned, is that a disqualifier for that factor?
I believe as a matter of law, it should be, unless in the examiner's decision, she gives a reasoned explanation why that statement by the offender was not credible, and she did not find it was established by a preponderance of the evidence. However, all the other reasonings she did credit, and that was sufficient to prove that this offender did not want to be treated.
Thank you.
So even if the application of Factor 2 to the shirtless back rub was not raised below, this court does have discretion to review a question of law raised for the first time on appeal if an injustice would result. And here an injustice would result if Doe's classification was increased in absence of substantial evidence that Doe had been discovered and confronted for sexual misconduct and went on to commit another sex offense, because this SORB says that that fact pattern is substantial evidence of the regulatory requirement for repetitive and compulsive behavior. It is a question of law whether Factor 2's adjective sexual is superfluous or whether the adjective, the verb confronted, is superfluous. And it's a question of law whether, in absence of any regulatory definition, do the words sexual misconduct and confronted have their ordinary meaning. So here the examiner applied factor 2 because she applied factor 2 because Doe committed inappropriate behavior. That inappropriate behavior was a 10-year-old girl whom he had known for 5 years, and he in fact stood in a position of a step-grandfather to her. She was seated on his lap. The two of them were watching Jurassic Park, and he was rubbing her back with his hand. If that was not sexual misconduct, but as the examiners called it, was instead inappropriate behavior, then the shirtless back rub was not, if the shirtless back rub was not sexual misconduct as ordinarily understood, then the statutory and regulatory requirement for repetitive and compulsive behavior was not supported by substantial evidence. And further, if the question, why didn't the girl have her shirt on, if that was not a confrontation of Doe where he was forced to face and account for his sexual misconduct, if that wasn't a confrontation within the meaning of that word, those words, then the statutory and regulatory requirement for repetitive and compulsive behavior was unsupported by substantial evidence.
I'm just want to make sure I follow your argument. Your position is that this was not sexual?
Exactly. And the regulatory definition of repetitive and compulsive behavior is the sex offender has been discovered and confronted for sexual misconduct. And sexual is an adjective that has meaning. It's not superfluous. It's not all inappropriate behavior that makes us feel uncomfortable or could be a problem, as Linda said.
Okay, I didn't want to miss the nuance of your argument. It's whether this was a sexual act. Is there something else about whether this was a confrontation?
Well, is saying, why didn't she have her shirt on? Well, that's asking about the girl's conduct. And he said, well, she took it off. And when the girl the next day said to the grandmother, well, he told me to take it off, the grandmother never went back. There was no confrontation of Doe that he was forced to face and account for, that in that shirtless back rub, he committed sexual misconduct so that he could understand that if he did anything subsequent to that, then he had already been confronted. And then the SORB would say, well, he's a repetitive and compulsive offender. So SORB appears to concede that factor 12 should not have been applied to the denial of parole. The law is fairly clear that DOC's placement of Doe on PES status because he declined sex offender treatment was not a rule violation indicative of unsatisfactory addressment to incarceration because of this court's finding in Butler v. Turco. I see everybody's nodding. Says that PES is an incentivization structure to encourage participation in programming, such as sex offender treatment programming, because DOC can't mandate the treatment. So it can't be a rule violation if it's not mandated. And the hearing examiner said she applied factor 2 simply because Doe had 2D reports. However, she applied no analysis of how these 2D reports over the course of 13 years indicated an antisocial behavior indicative of a high risk to reoffend or rule violations indicative of high dangerousness. And this was important because DOC said that Doe was not a management problem. If Doe was not a management problem, then in effect, they were saying he had satisfactorily adjusted to the rigors of incarceration and that his behavior was good as opposed to antisocial. And the hearing examiner erred because she didn't consider the seriousness of the violations as was recommended by Factor 12. And in this case, we see the seriousness of the violations. It wasn't serious. One was for lying and in 2018, and no penalty was imposed. Clearly, DOC didn't think it was serious. And then the 2012 that he got into the fight. The record said he'd been attacked 6 times at a minimum. So he gets into one fight. But the discipline imposed, again, was minimum. 1 day loss of canteen when their regulations said it could have been 30 to 90 days. And 1 day in detention when their own regulations said up to 15 days. So standing alone, the 2D reports didn't demonstrate high risk and high danger. And I see that I have a minute left. If there aren't any further questions, I will sit down.
Thank you.
Thank you so much.
Good morning. If it pleases the court, David Chennai for the board. I'm sure you're probably aware that I'm going to say that the hearing examiner's decision was properly made under the circumstances. She did a great analysis of the evidence and I think balanced out all of the different factors in this case. And I think the level 3 was warranted under the circumstances of this case. I think that factor 2, even if you take factor 2, I think that one there, I think it was properly applied. If you take factor 24 and 12 out of the analysis, I think there's still substantial evidence to support the level 3 classification based on the circumstances of this case and the fact that this individual has not really shown any growth as opposed to the plaintiff in, I think it's 22188, comparatively speaking. So I would ask this court to adopt the board's classification in this matter. And unless there's specific questions, I'd be more than happy to rest on my brief at this time.
Could I ask what more specifically is the board's position with respect to factor 12? What was properly considered, and if anything wasn't properly considered?
I think the hearing examiner based it on the 2 disciplinary reports and his overall progress. I think the hearing examiner felt that he not being able to do any institutional programming for the I think it would be about 6 years since he was put on PES, and the fact that and the actual hearing date, I think that was part of it. And I think looking at it qualitatively, although he wasn't an adjustment problem in the sense that he caused problems, what he did, though, is he put himself outside of the institutional programming. He put him outside of basically being part of the general population and adapting well into the system of incarceration. But again, you can look at that as the hearing examiner's decision is probably the weakest part of the decision. But again, I don't find that taking 12 out of the analysis would lower this individual's classification at the time of the classification hearing.
As to factor 24, does the hearing examiner have to make a specific finding as to why the offender did not do treatment?
I think the factor says refuse to participate in treatment. And in 2018, he refused again. He refused in 2015. His only appeal, which he claimed in 2015 was the reason for his refusing treatment, had been resolved in 2012. So I think the hearing examiner didn't have to go into an analysis of the confidentiality because in 2018, he refused treatment. And there's no evidence anywhere that it was based on confidentiality issues or it had a legitimate basis in confidentiality at that point in his, what we know of his appellate history. So I think 24, I think the hearing examiner applied it properly under the circumstances.
Could I ask this? I don't recall whether the record includes information that the hearing examiner would have had or did have about the existence of, let me start that again. Does the record include evidence that shows that there was no actual appeal pending in 2015?
What it showed was that in 2012, his SJC case was finished and published, and that he claimed, self-reported, that he had an appeal pending. I think he may have testified this, but he had an appeal pending, but he didn't have any information. He didn't know the status of it. He claims it was in Boston Federal Court, but he had no other information. He didn't even have information as to who was representing him in the appeal. So I think the hearing examiner didn't have to accept that testimony as proof that he still had an appeal pending. I think that if an appeal was pending, he would have been able to bring in some documentation or some information that would verify that fact. It was his assertion that it was pending, so the burden would be on him at that point to prove that it was pending. I don't think the hearing examiner had to go out and seek out and find out and check all the records to make sure that nothing was pending at that time.
Thank you.
Any other questions? That's okay. Thank you.
Thank you. Have a nice day.
Matter is submitted. And for our final case, Department of Children and Families versus Mother, 23P1420. Again, this is another case involving impounded material. Ask the parties to refer to the individuals involved by pseudonyms or by their designations.
Good morning, and may it please the court. My name is Eric Soul, and I represent appellant Mother. Termination of parental rights is an extreme step. For a court to do so, it must find all three of the following: that a parent is currently unfit, that the unfitness is so probative and so persuasive that it's likely to continue undiminished into the future, and clear and convincing evidence that termination is in the child's best interest. Here, just to be clear, we are not arguing that the mother was fit at the time of trial, although I think a strong argument could have been made about that. Instead, we're arguing what we feel are the two stronger arguments, that it was likely that her unfitness would be diminished in the future, and that termination was not in the child's best interest. Because I have limited time today, I'm going to start with the best interest argument, and then if there's time, I will move on to future fitness. In this case, there was not clear and convincing evidence that termination was in the child's best interest. In fact, terminating his mother's rights here ran counter to the child's best interest, in that all it did was eliminate a potential permanency option for the child, and not just a person, but perhaps the most important person in a child's life, her mother. First, mother and child had a bond, and that's evidenced by the fact that the judge himself ordered post-termination visitation between the child and mother. So he clearly recognized that there was a bond and it was in the child's best interest to keep some relationship going moving forward. Second, it should be noted that at trial, DCF was the only party who was advocating for termination. Mother was against it, child was against it. Even the foster parents, through the adoption plan, stated that their wishes were for the child to be placed with parents or other family if possible. Now, with that in mind, the court made a clearly erroneous factual finding, which cast serious doubt on whether even it believed termination was in the child's best interest. And that was factual finding 300, which states the department's goal for the child is adoption by her current placement. That was not the goal per DCF's own adoption plan. The actual plan called for maternal grandmother to be prioritized first for placement, and then foster parents would be looked at second.
And at the time of trial, was the evaluation of the paternal grandmother still ongoing?
During trial, ICPC, because maternal grandmother lived in New Hampshire, was going. By the end of trial, it was still pending. And again, in the adoption plan, the foster parents made their wishes clear that they wished for the child to be placed with parents, if possible, or other family. So it appears the court mistakenly believed that the foster parents were to be prioritized first for placement. And I think it's reasonable to conclude that if the court believed that, then the court reasonably believed that foster parents were eager to adopt and were just waiting for a termination decree to enter before being able to do so. If that was the case, then of course termination would have created permanent and immediate stability for the child, which is something a court must look at. But again, that was not the plan here. I think if the court correctly understood that maternal grandmother was prioritized first and ICPC was underway, that their wishes, foster parents' wishes, were for the court to be placed with a parent or other family, presumably like maternal grandmother. I think that would have tipped the decision away from termination in this case.
What about the suggestion that the plan that was submitted by the department anticipated that the maternal grandmother wouldn't be approved?
It's possible that the plan, there is a footnote that says maternal grandmother was denied previously because she couldn't complete a training course or something like that. There was no indication in the ICPC process that was underway in this case that she was unwilling or unable to complete the training that she didn't previously. In fact, she's the one that contacted the department, telling them she wanted to be a adoption resource for the child. So I think this clearly erroneous finding may very well have tipped the judge's decision towards termination. I think this is especially true given the fact that mother was making great progress here. And whether a mother's fitness or a parent's fitness is temporary can also be framed as a best interest argument here. And as I've made outlined in great detail in my brief, by the end of trial in June of 2023, mother had made great progress in many areas, and at the very least, the trajectory of her fitness was certainly headed in the right direction. By the end of trial, there was no evidence of ongoing substance abuse issues. There was no evidence of ongoing unlawful activity. She was working full-time in New Hampshire. She was living on her own. She had separated and hadn't lived with father in this case in nearly a year. The evidence showed that she hadn't seen father at all face-to-face outside of court in nearly 8 months. And
what was erroneous about the judge's conclusion that the mother's mental health had remained unaddressed at the time of trial?
So mental health was the one issue. I don't think that, if you can point me to the conclusion, but if you look at the judge's findings, he seems to base his decision on 4 things: mental health being one, substance abuse being another, domestic violence, and criminal activity. 3 of the 4, there was no evidence there was any ongoing issues by the end of trial. Mental health was one mother has admitted that will be an ongoing issue for her. There was evidence she had re-engaged in therapy, had a psychiatrist, was back on her medications, but I don't believe I'd have to look at that actual conclusion. But mental health is the one area where she agrees she needs more work, and there was evidence she was moving in that direction. Just briefly, because my time has expired, all we're asking for this court to do is vacate the order which terminated mother's rights. All that will do is allow her to go back to court so all the parties can update the judge on the most recent evidence. The child will stay where she is, and DCF will retain custody.
Thank you.
Thank you.
Good morning, David Perlman, representing the appellant father. So I essentially want to touch upon three issues that I address in my brief. The first one is that if the father is fit for the older child, then he's certainly fit for the younger one, whose rights were terminated, absent specific findings as to why the younger child would necessitate special parenting skills that the older one did not require.
Was the older child's fitness an issue for the judge? I mean, the father's fitness to parent the older child an issue that the judge was called upon to decide?
No, however...
Did he decide that?
So there were two children on the petition originally. One of them aged out. However, prior to aging out, the department returned him to the parents. And then there was an incident in June of 2022 where the father took his son to Rhode Island for about 2 to 3 days, and then the child ended up in foster care. But the bottom line is that in May of that year, the department had determined that father was fit enough, at least, to have his son returned to him.
But isn't it your argument that the judge erred by concluding essentially that, or endorsing some conclusion of DCF's that the father was fit to parent the older child, but not the younger child?
Yes, because essentially...
And so my question is, where is that first finding? Where is the judge making any determination about DCF's judgment with respect to the first child?
Well, the judge does make findings saying that the father seemed to be able to parent right for his basic necessities. The record reflects that with the father from age 5 to 12 or 13, so that's a span of 7 years where there were essentially no concerning incidents. Part of the record was a school guidance counselor saying that father is very attentive, responsive, appropriate. So it is unclear why, if the court was not questioning the department's judgment around fitness for the older child, that there would be a question as to the younger one when there were no special findings. And in fact, the opposite was true, where the court actually determined as fact finding 283, and I quote, does not have any special needs. And under adoption of RONA, if you are fit for one child, you need to specifically delineate why a parent would not be fit for the other. And when we look at the subsidiary findings, only 10 out of the 309 were about, only 17 out of the 309 were regarding best interests for, and in none of those...
I think maybe if you would avoid using names.
I'm sorry. And in none of those, not a single mention of the relationship between the father and the younger child. So I would argue that if the parent was able to be minimally adequate for one, he was minimally adequate for the other, absent some kind of articulation for as to why that was not the case. There must be a nexus between the conduct that the department is deeming to be concerning from a parental capacities perspective and the actual ability to parent a child.
I guess I'm following up on Justice Hand's question.
Yes.
So you think the judge needed to specifically make a finding that said that father should not have been the parental parent of older child?
No, I'm suggesting that there should have been a finding regarding that he's not fit for the younger child with particularity. explicitly explaining why it was fine for him to have the older child but not the younger child.
I guess my view of that is he was never called on to make a finding regarding older child. So why does he have to make that specificity with younger child?
It's relative to the best interests of the younger child because the older child was a part of the care and protection during the pendency of the case, and but for turning 18, there would have been a finding made about the older child, presumably. And so from the perspective of gauging... But
you're asking us to guess what that judge's finding would have been if the child hadn't aged out. And that's where I'm sort of having the disconnect.
Well, I'm asking to remand to find out rather than guessing. So there's... One doesn't have to necessarily reverse, can also remand for further detail.
My first part of my question was, so you feel then that on remand, the judge has to make a finding regarding older child, even though older child's not part of the case?
About younger child, who was a part of the case.
He did make a finding regarding second child, but nothing in relation to the older child.
There were no special findings regarding why he would not be able to parent the younger child. It was more generic that there was concerns about patterns of past behavior emerging in the future, but there was no specific articulation as to why this particular parent would be unfit for this particular child. If I may, I do want to address one other important issue, which is regarding post-adoption visitation. So the lower court, perhaps it was an oversight, but the lower court did issue post-termination visitation, but was silent as to post-adoption visitation. And under adoption of Douglas, it's pretty clear that a parent has standing to appeal essentially any aspect of a visitation order.
Was that argument preserved?
It was not mentioned during the trial. However, the Douglas language actually says unless expressly waived, the exact language, a parent has standing to press on appeal any challenge that he or she has not expressly waived to that adjudication. And it was certainly not expressly waived. Furthermore, there's a statutory right to sibling visitation, at least, and that is, General Law, Chapter 119, Section 26B(b). And there's nothing in the plain language of the statute that says that a parent needs to preserve at trial court to exercise their right under the statute.
And what's the standing? If it's the child's right, what is the standing of the father once he's been decreed unfit to raise this issue?
In adoption of Douglas, the language says can appeal any part of a visitation order. So that would include presumably siblings being able to visit one another, which is what the statute contemplates.
Thank you.
May it please the court, Julie Gallup on behalf of the Department of Children and Families. The department is asking for this court to affirm the decree of the lower court terminating mother and father's parental rights, as there was overwhelming evidence of their unfitness. None of the findings are clearly erroneous, and parents' arguments merely amount to dissatisfaction with how the judge weighed the evidence and assessed the witness's credibility. As to mother and father, we have over a 20-year period of instability with regard to mother, substance abuse, mental health issues, which resulted in explosive and violent behavior, and between the parents, long-term domestic violence concerns. Now, with regard to I will speak to mother's arguments with regard to the adoption plan. The adoption plan as written does reference that an ICPC of maternal grandmother was ongoing at the time of trial. And it also references that the pre-adoptive family is the adoptive resource, and the adoption social worker testified to that fact. So the reference that my brother alludes to of the statements of the pre-adoptive family identifying the importance of familial connections and relationships was just that. They were acknowledging that the importance of those relationships, but they were in no way saying that they did not want to be the child's adoptive resource. And so the judge found that this plan for the child served child's best interest. And it was not, finding 300 is not clearly erroneous, as there is evidence in the record to support it, and one is not left with a distinct impression that a mistake has been made. Now,
well, did the judge make a mistake, and I'm switching to visitation, not referencing post-adoption and post-termination?
I would argue that the absence of an order for post-adoption visits, it suggests the judge implicitly found that such an order did not serve child's best interest, and so that it was not an error to say, I'm not ordering this. The absence of the order suggests that the judge found it not in the child's best interest to maintain ongoing contact with the family. Post-termination visits, exist while an appeal is pending, or until permanency has been achieved, but the permanent plan is for the child to have a relationship with a new family, the adoptive family. So I would argue that there was not an error, and the judge, it's implicit in that in that order, that it was not in the child's best interest to maintain that contact. I'm going to jump around a little bit. So I guess switching back now to mother's arguments about the potential temporariness of her unfitness. Again, the judge had a 20-year record of issues of unparental traits and conduct, and did not need to necessarily have the same faith that mother had, that she could maintain the stability that she had perhaps had for some period of time while the trial was ongoing. So the trial began in February of 2023, and mother did not resume mental health treatment until May of 2023. So, and mother herself concedes that the mental health issues are ongoing and will likely be ongoing. But as a result of her mental health, both child and son, the older child, were exposed to extremely explosive behavior, violent assaults, and instability, to the extent that son testified that it was, there was not domestic violence between the parents, but that father needed to, throw mother to the ground or restrain her to stop her from hurting herself, and that was reasonable. Or I guess that would be my inference, that testimony to the son, that this was not domestic violence. These parents had a pattern of separating and then reuniting. And so with regard to father's argument about whether he was able to parent an adult, an 18-year-old, I just want to correct one thing that my brother said. DCF did not return son to his parents' custody. The older child had, I think, eloped from a foster placement, and it was in the interest of his safety and making sure that he was around. We knew where he was, that he could live with father until he turned 18. But custody itself was not returned. Additionally, the argument that there should have been a comparison between the two. The judge discussed how, while son was living with his parents, he was exposed to their arguments and their explosive behavior, and that caused stress, which, the Supreme Judicial Court has recognized in custody of Euan as, domestic violence having such an impact on children's emotional and mental growth. So additionally, the judge did not credit some of the parents' testimony about the violence or absence thereof in their relationship. Frequently, the judge found the parents not to be credible on those points. Now, with regard, I'll just speak briefly as to Mother's argument about remand. This child deserves permanency. She's been in the department's custody since 2021, briefly in 2020, and, now we're in 2024. The judge spoke of, in one of the conclusions of law, that at the time of trial, I believe child was 3, and she'd spent her 24 months in the department's custody. The parents had an opportunity to engage in services and demonstrate that they were able to rise to the occasion and, correct their deficits for the interests of their child. And they did not do that, and the judge found so. So we are asking for you to affirm the decision. Thank you. Or, if there are no other questions, I'll rest on my brief. Thank you.
Good morning, Your Honors. Attorney Svetlana Gerova-Wilson for the child. My client, it's undisputed that at the time of trial, it would have been in my client's best interest to return to a fit parent, or at least to a parent that might become fit in some foreseeable future. My client wanted to, at the time of trial, she was advocating for finding of unfitness but not termination, because she was hoping that she would be able to return to her mom. However, those wishes have changed, and she's entitled to do so. My client will be turning 5 next month. She was almost 4 years old. She was going to turn 4 in August last year at the time of trial. She does deserve permanency, as mentioned, and it does not really matter what the judge believed in terms of where she was going to be adopted, who she's going to be adopted by. The judge did believe that she'd be adopted by her current pre-adoptive home. However, under adoption of Gertrude, it's 99 Mass Appellate Court 817, and my apologies, I have not included that one in my brief, but the appellate court found that you don't even need pre-adoptive home in order to terminate parental rights if the parents are unfit, and it is not reasonably likely they'll become fit. And unfortunately, this is what the case is in this matter. Mom and dad, there's no question that they love my client. However, both of them have had mom had had 3 other children, father has 3 other children with the older brother of my client. Mom was not able to parent either one of her kids. My client's older brother, Mom has lost her temper twice on him. She had bit him. I have included that in my brief. She bit him twice. The last time she bit him was he was trying to pick up some things. He was trying to move out. He was 17. He was trying to move out of the home, and she bit him on the back, necessitating hospital care overnight. And that happened not long before trial. In terms of the domestic violence, to me, this is the overarching issue. Mother and father have been together since early adulthood. As mother testified, she has been with father for 20 years on and off. There are horrid incidents of domestic violence. Horrid and recent. This is the most disturbing part. I mean, father had kicked her and punched her when father found out that mother was pregnant with my client. And my apologies for being graphic here, but he made a statement to his son at the time, "Watch me give your mother an abortion." And he punched her in the ribs and kicked her. All that happened in the presence of a child. Also,
can I ask what
yes.
your client's position is regarding visitation with the half-brother?
So, Your Honor, my client is content with having visitation with her brother determined by her pre-adoptive placement, and she's not appealing the lack of finding. And that is, you're correct that right belongs to her, and she's not asking for an order. She was not asking at the time of trial for an order of sibling visitation, and she's not asking for any reversal of the judge's opinion whatsoever, of the judge's, I'm sorry, judgment. And in terms of temporariness, there's plenty of evidence for the judge to find that the unfitness was not only temporary. And to quote Adoption of Ilona, hope alone that the parent will become fit at some point in time is not enough. We need more than that. We need specific steps. Mom has done some steps. She claimed that she had separated from father. However, the judge found in conclusion of law 25 that the mother and father have had a pattern of abusive relationship over years and breaking up multiple times, and he did not credit her statement that mother and father have separated at least permanently. And they have found that they have placed the toxic relationship over the needs of their child. And the judge simply did not believe that this will end. And in addition, there's less important issue in my view. The mental health is a serious one, as evidenced by mother's sporadic care and very recent at the time of trial mental health care, but also the fact that she lost her temper at least twice with her child, with her older child. It's indicative of the fact that she does not have things under control. She had made suicidal statements more than once, including in front of the teenage son. In terms of substance use, the judge did not rely heavily on that, is my impression. She has had substance use problems, but there's not evidence that they were that recent. However, the judge did find that, if I'm not mistaken, that she does have propensity to relapse. And at one point, she was positive for heroin, but then she said, well, I didn't take enough. So it didn't show on the test, on the blood test, I believe. So the judge did not trust her ability to remain sober, but I don't think that was the overarching concern. I think the overarching concern was the domestic violence between the parents. And it is very clear that there was plenty of evidence that was not going to cease at any time in foreseeable future. And again, my client, her childhood is, it's not going to last forever. I mean, being almost 5, being kindergarten age, she does deserve permanency. And she's asking that Your Honors affirm the lower court judgment and allow her to be adopted by her current provider, whatever pre-adoptive provider she is, she'll be in the care of.
Thank you.
Now, I rest on my brief, Your Honors.
Thank you.
Thank you.
So this concludes the cases that we have on for today. All the matters are submitted. I want to thank all of the court staff for making